Hello, my name's Sam Skinner, and I'm a barrister at the 36 Group in London. We're here in week 94 of lockdown, and what better way to pass the time than to listen to a short, pre-recorded lecture about making written representations in fraud cases. Over the next 10 minutes or so, I'm going to talk about how written representations before an indictment is preferred can persuade the Crown to drop cases of fraud. I'm going to start by looking very briefly at the law that has to be applied by the CPS when deciding to discontinue a case, and then look at where we can find the guidance that the CPS will rely upon when making a decision about discontinuance. Then we'll have a quick look at a set of written representations from my collection that didn't do the job in persuading the CPS to drop the case, and I'll explain the reasons behind that decision. And finally, we'll have a quick look at a set of written representations that did persuade the Crown to drop a VAT fraud case before the indictment was preferred. And you can see how those written representations were set out in an entirely different way to the set that had no effect. So we'll begin by looking at the relevant bit of the law. Well, the relevant piece of legislation is the Prosecution of Offences Act 1985, and in particular we're looking at Section 23A, which deals with discontinuance of proceedings after an accused has been sent for trial, but subsection 2 specifies that it is at any time before an indictment is preferred the proceedings could be discontinued. And in order to discontinue proceedings, the director has to give notice. Well, how will they make that decision? They'll apply guidance and the law to the facts of the case. And if we go back into the table of contents of the Act and look at Section 10, we can see that Section 10 gives the Director of Public Prosecutions power to issue a code for Crown prosecutors and guidance on general principles to be applied in charging offences, but also in deciding whether they should be discontinued. So now we know that the Crown Prosecution Service have applied the 1985 Act in deciding to charge our client with a fraud offence, and we know that the CPS also have the power to discontinue that charge against our client, so long as an indictment hasn't yet been preferred. Well, what's going to cause them to discontinue a charge against our client? Well, one of the things that can help is that if we make written representations to the Crown Prosecution Service, setting out, by using their guidance and the Code for Crown Prosecutors, the reasons we suggest that the decision to charge in the first place was wrong. Let's have a look at some of the guidance that the CPS rely upon now. Well, this is the Code for Crown Prosecutors, which was referred to at Section 10 of the 1985 Act, and you'll be very familiar with this if you prosecute, perhaps less so if you defend. But this is the starting point for charging offences, and it's a two-stage test. We're thinking here about the full code test, and the first is the evidential stage. Is there, on the evidence, a realistic prospect of conviction? If there is it in the public interest to prosecute? And you can see here that the CPS have numerous factors they've got to take account of when deciding whether or not a prosecution is in the public interest. Now, it's not just this Code for Crown Prosecutors, which does contain at paragraph 10 how a prosecution decision should be reconsidered, and it's this paragraph that means that when we send our written reps, they can't just be thrown in the bin. They've got to be responded to and considered. But there's specific guidance that will draw to the CPS's attention in our written representations. In a fraud case, it would make sense to refer to the Fraud Act guidance. We want them to discontinue the case, so we'll have looked up in advance the termination of proceedings, including discontinuance guidance, and we'll make sure our representations tick those boxes. There's more recent guidance. Coronavirus. We'll want to make sure that we're up to date when we make our written representations. And, perhaps most significantly of all, when defending, we know that disclosure is an important issue, and we can see here that the CPS have 12 separate pieces of disclosure guidance that we'll need to be familiar with and refer to, if necessary, in our written representations. We also got to bear in mind that if we succeed in persuading the CPS to discontinue the case, there's a victim's right to review scheme, so we need to make the CPS's life easy by ticking the boxes when we make the reps. Whatever the alleged offence, there's specific guidance for it, and if it's an elderly or non-recent offence, specific guidance for that. We need to be familiar with this when we make our written reps. And perhaps if it's a VAT fraud case, such as we'll be looking at later, it's not just the CPS guidance we need to be aware of. The revenue, they have their own. We've looked at the law now, and I've shown you where we can find the relevant guidance that we're going to have to refer to when we make our written representations to the Crown to discontinue the case against our client. What we're doing now is drafting the reps, and we're into the realm of written advocacy. Anybody can write a letter, but it's the way that the letter is written, helping the CPS to come to what we suggest is the right decision, that may make the difference for our client in the case that we're concerned with. The substance of these written representations are from a genuine case that I was involved with, but I've changed the names and the dates and the addresses so that anonymity is preserved. And we can see here that Molly Weasley, the mother of Ron Weasley and various other Weasleys, has been accused of an offence of dishonesty, but her solicitors have written to the Wizard Prosecution Service pointing out that the case should be dropped because she is of previous good character. They also suggest that prosecuting her is going to have a significant impact upon her future, and that it's almost a year since the alleged offence took place. She's not been arrested for anything in the intervening period, and therefore her human rights will be breached if she is charged and prosecuted for this offence. Now, I suppose that this letter is technically written advocacy, but it's not very good. It doesn't make any reference to the guidance or the law. It doesn't say, other than that she's of good character, why the case against her should be dropped. It doesn't refer back to the evidential test or the public interest test. Really, what does it amount to other than a cry for mercy? Well, you won't be surprised to discover that these written representations, when they were submitted, did not persuade the Crown Prosecution Service to discontinue the case against this particular defendant. But let's have a look at a set of written representations that did. These representations are also taken from a real case, but I've changed the names to protect client confidentiality. We can see here that Super Ted has been charged with VAT fraud, and he has instructed his lawyers to submit written representations for the case to be discontinued before an indictment is preferred. And Super Ted had the good sense to instruct a member of Her Majesty's Council and an experienced junior from the 36 group to draft these representations. And we can see, unlike the previous set of reps, these representations refer back frequently to the Code for Crown Prosecutors and the guidance that the reviewing lawyer has had to take into account when deciding to charge this case. One of the more important things to bear in mind when drafting written representations is to make sure you don't give away too much of a client's defence at this early stage. How that can be managed is written advocacy, and as a matter for judgment and experience, because things could go very badly wrong. But in this case, we can see from the representations that the arguments being put forward are attacking the credibility of the prosecution witnesses and their failure to deliver up important accountancy documents. These arguments have plainly been put before, presumably when the defendant was interviewed by the police. So there's nothing new in making these arguments. They're simply being drawn together as part of the written representations. So in that exercise of judgment, it was safe to disclose that this would be the main plank of the defence. The public interest arguments, too, have plainly been raised before, especially in relation to the defendant's health. But we can see that for each factor that's set out within the Code for Crown Prosecutors, there's an argument made within these written representations referring back to that factor for a reviewing lawyer at the CPS to consider when reading these written representations. Now, I'm not saying that these written representations are a perfect example of the type, or that they should be copied. I'm sure that the author would write them differently if he or she were instructed to draft them today. But they're considerably better as an exercise in written advocacy than the previous set, trying to get Molly Weasley off her allegation of dishonesty. And they're significantly better because they engage with the Code for Crown Prosecutors and the guidance. When making written representations before an indictment is preferred, it's the Crown Prosecution Service reviewing lawyer who makes the decision. He or she is the person who needs to be persuaded. And not only do they have to be persuaded, but it's got to be proof against a victim's right to review. These are difficult hurdles to overcome, but as I've already said, these written representations worked, so they're not impossible hurdles to overcome. It's simply a question of advocacy and showing the decision maker the way home. So I've set out the law that allows the Crown Prosecution Service to discontinue a case against our client. And I've set out and shown you where you can find the guidance that will help you seek to persuade the reviewing lawyer to discontinue the case. We've looked at a set of representations that didn't work and a set that did. Thanks very much for watching.